I think it's time to resume the meeting. The purpose of this meeting is to receive deputations and individuals and their views on the Copyright Amendment Bill 2014. I'd like to welcome you all to the meeting. Please wear your earpiece, and if necessary, please choose a channel of your preference. Channel 0 is floor, channel 1 is Cantonese, channel 2 is English, and channel 3 is Putonghua. First, I'd like to remind deputations and individuals. Now, apart from members and officials attending this meeting, your oral representation and your written submissions are not covered and exempted by the Legislative Council Powers and Privileges Ordinance. So deputations and individuals, please pay attention to the fact that if you attend meeting in rooms of this building, and also if you are in the public gallery, please avail yourselves to the notice. The notice contains the security rules, and also you have been sent a copy together with the secretary's letter to you. Those in the public gallery can ask for a copy if you need to from the security staff. There are 4 sessions to this meeting. Since we have a big number who have registered to attend, I will ask each deputation and individual to speak. Each of you will have 2.5 minutes. You just need to point out the main points in your submission, and you don't have to repeat everything in your submission. The convention is that all submissions received have been uploaded to the website of the Legislative Council and have been issued to members. If members have not sent in any written submissions or you have supplementary views, please do send them to the Secretariat after the meeting. Also, when you speak, please do not use a mixed code because we have simultaneous interpretation services at this meeting. First, I'd like to invite Mr. LEE Hing-ming to speak. Hello, good afternoon. I object to the addition of any kind of powers for the government. In other words, any new addition of criminality to the copyright law. As you know, we see selective law enforcement. Even if I share a picture on Facebook, I don't know whether I would be taken to task later. We have seen people being beaten up in a dark corner. Now, maybe after the bill is passed, we will be prosecuted. Thank you, Mr. Koo Chun-hin from NEO Democrats. This is our position on the bill. In 2011, when the copyright bill was amended, the administration was already criticized for enacting Article 23 of the Internet. And now you have come up with this new bill incorporating other views. Our stance is like this. We object to the bill because you only provide exemption for parody, satire, caricature, and pastiche, and also commenting on current affairs and also quotation. We believe such exemption cannot cover every kind of secondary creation, and you are forcing people just to make jokes of the original, and also people doing secondary creation would be relegated as clowns. However, if we are serious in rearranging the original music, if we put new lyrics onto it, we will still be breaking the law. So you are putting constraints on the way we do our creation. We believe you deprive us of the freedom of creation. And also parody, satire, caricature, and pastiche. These terms are very vague. There are no clear definitions of these words in the law. We will have to rely on court rulings as case law. So when people do their secondary creation, they are trying their hand at the law. They don't know whether they are going to break the law or not before a court ruling is made. And also, caricature contains or carries no objective standard, so we think it is hard to accept. And the New Democrats would also think that the exemption of UGC would be the best way to balance free creation and the copyright owner's rights. UGC does not put a constraint on the way secondary creation is done. It only puts constraints on secondary creation for the purpose of profit making. However, you make use of the excuse that this is not internationally adopted. Next, Mr. Lo Kun Yu.
Over-regulation corrupts freedom of speech and weakens the rule of law. It benefits monopoly controls. I can't believe that we can still protesting this budget held after this bill has passed. That's all I said.
Okay.
Mr. Chairman Long. There are exemptions in the bill. It's just a sugar coating because you are not including a lot of scenarios. Like the Harcont Road village outside this building, they love to sing the birthday song nowadays. But some people may want to sing it in a special way, and it will become very sad, and I'll sing it now.
Happy birthday to Sea Island. Happy birthday to you.
So I'm just turning this birthday song into a tune that carries sadness. And yet I could be caught by this bill and I could be criminally prosecuted. So I really urge you to consider UGC in addition to the so-called exemptions in the bill. That's all. Ms. Chu Ho-yen.
Good afternoon, ladies and gentlemen. We are Hong Kong Recording Industry Airlines Limited. We are a not-for-profit copyright management organization. We have a few comments on the bill. First, Section 28A on communication right. A communication right introduced here is to enhance copyright protection for electronic communication of a work. In the digital environment, we all know that a work will be transmitted and retransmitted. But subsection 5 seems to have removed acts of retransmission. So we suggest both subsections 5 and 6 be removed or redrafted. And next, we'll look at sections 39 and section 241 of the bill. We're looking at subsection 2 on quotation. It says here that copyright is not infringed by the use of a quotation from the work, whether for the purpose of criticism, review, or otherwise, if it fulfills the listed requirements. Now, what is otherwise referring to? It is not clear, and therefore we suggest removing the word otherwise. And looking down a little bit at the list of requirements for quotation, under bracket C of subsection 2, it says the extent of the quotation is no more than is required by the specific purpose of what it is used. We suggest enumerate the list of specific purposes under subsection 2C. And we also have a comment on subsection 3, reporting and commenting on current events. We suggest adding requirements similar to subsection 2 on quotation. And we would also like to point out that it looks like there are maybe some overlap with the existing section 39, criticism, review, and news reporting, the proposed exceptions for quotation and parody. So we'd like the government to look further into it. And next, section 39A on parody, we suggest to add 2 requirements. The first is directly or indirectly acknowledging the source of original work, and then two, the parody constitutes on an original work in itself.
下一位係吳仲達先生。
好，多謝主席。
NG Chung-tat, the proposed amendments, whether it's the one proposed 3 years ago and the present one is very narrow in scope, although there's a fair dealing provision, the mechanism is very restrictive. So if we don't satisfy the true requirements for exemption, we stand a chance of being prosecuted. Whether prosecution is successful, people's incentive to do creative work will be stifled. Many people do creative works to share their thoughts. Mr. Ma Feng-kwok said today that he doesn't know what second creation includes. The government has already proposed certain types of exemptions. With all these restrictions, people will not be able to freely express their creative ideas. In other countries, they have regulations governing derivative works in order that we can allow for creative work in this internet age, where people may rearrange lyrics or music and so on. We don't know whether or not in future there will be new forms of secondary creation. It's exactly because of that that the UGC proposal will provide a principle so that we can have protection for second creation. The government is not prepared to consider UGC because only Canada has such a legislation, and therefore UGC is not an international standard. But why is it that the MPCSC made a decision which does not provide for popular election that is up to international standard? If you in the bill, you have quoted many, many American examples, but the spirit behind the bill is very different. In the United States, when they deal with disputes over copyrights, they would use the fair dealing or fair use principle, which is different from the fair dealing provision. Fair use is more flexible, and in dealing with such cases, the basis is that they will not stifle creativity. Even if they have different types of exemptions, they emphasize that those exemptions are only examples. When new scenarios arise, they will make a judgment on the basis of the fair use provision, rather than require us to satisfy all the requirements as in the present bill. And you've ever made reference of U.S. open system, but 10 years down the road, the system right now is still very conservative. Next, Ms. Lee Pick-Wan. Recently, Premier Xi Jinping made a speech in Brazil. He proposed that we should have build up a more transparent and democratic internet network, so that we can together build a peaceful, open internet space. But in China, they always tell the people that you are now being, monitored by other countries. Your secrets are known to some foreign countries. So if one doesn't put one's secrets onto the internet, nobody will be able to access such secrets at the moment. Let us not forget that we don't have freedom, internet freedom. Certain countries like the United States, they do provide internet freedom. Now you've limited all the sensitive words. You don't allow people to access YouTube, Yahoo, and so on. You restrict the people to access the internet. And even if you send out a single message, or your friends have sent out, unacceptable messages, they'll be arrested. And they've also built firewalls to monitor their own netizens. So the whole idea is that they don't want the people to know too much. The least they know, the better. Although we are called one of the 4 ancient civilizations, but our culture is really very, very backward. The important thing is that people shouldn't know too much. Why is it that you don't want the people to know? Why is it that they shouldn't have the right to know? It's because they want. So that the Communist Party can rule the country without the people knowing anything at all. Secondary creation is a tantamount to the internet version of Article 23. Now, honestly speaking, if the Article 23 were enacted, so you don't even if we don't have this internet version of Article 23, we will be doomed. And also, let us not forget that the internet version of Article 23 is the same. It's equally potent a weapon. You are restricting secondary creation. The result will be equally dire, because the people no longer will lose democracy, the democracy and freedom. Mr. Lai Cheng, we are a group of Kaifongs living in public housing estates. Although we come from the public housing estates, it doesn't mean that we are not concerned about this topic. The housing, we are affected by the housing department's policy about, tenants who are given very lenient housing accommodation. The concerned group is very concerned about any proposal to amend the law, because we think that existing arrangements can already protect the original author of the copyright works. The Kaifongs have to resort to changing photos or resort to satire or on government policies and what officials have said to help us promote or educate those people who don't understand the issues, so that they can have a good grasp of our present predicament. So when the government, although the government said that they will provide for exemptions from criminal prosecution, but under the framework of such exemption, does that mean that everyone involved in secondary creation, before they do any secondary creation, they have to consider bear this framework in mind? If they have to bear this framework in mind, they will not be able to set loose their creativity. So for the ordinary citizens like us, I think we have a role to monitor the government. We want to show what the government see what it has failed to see. The government, through the media, newspapers, and TV and radio stations, he sent out a message that they don't like certain movement, and so therefore it is important that we have the right to express ourselves. Even though we are humble residents of public housing estates, we are prepared to defend the rights that we enjoy now. We don't want Article 23. We do not want the freedom of public housing estates residents to freely express their creativity. Thank you, Chairman. The Internet Article 23 should not be allowed. In Western countries, they really encourage secondary creation. The topics covered by secondary creation could be environmental protection, or they don't think there's any harm in secondary creation. Very often, we find that in these secondary creation, there is no self-censorship. And the people's creativity are not restricted. There are many people who are creative. In Hong Kong, everyone is now afraid and they are subject to restriction. In the past, creation simply is a way for us to express our dissatisfaction with the government, or that we don't want to see the government carry on with policies that really hurt our public interest. In other countries, they have satires and I think and caricature against the government, and they would regard them as a reminder, and the government will not stop those creative works. Whereas in Hong Kong, we are in this present predicament, and we are resorting to Article 23 to stifle the expression of our opinion, or the expression of our aspirations, or our dissatisfaction. Is it really the case that we all would need to? Is it really the case that Hong Kong will become a better place if all of us are silent? Honestly, I don't want to become an ignorant person. We have the right to know, and whatever the government does, I think we have the right to know what the government is doing. We don't want this Internet Article 23 because it will stifle the the space of creativity for everyone in Hong Kong. So I support the provision of space for secondary creation. Thank you, Chairman. As a Hong Kong resident, first of all, I think that the original author of the copyright work should be entitled to his own rights. At the public hearing, we want to express our own opinion and the views of the netizens. We don't want to inadvertently break the law. In Hong Kong, we're still talking about the rule of law. We're not talking about the rule by men. We don't want to deliberately breach the law. As an ordinary citizen in Hong Kong, I myself like secondary creation. And this morning, many people already made various arguments in favor of second creation, and I decided to repeat them. But the products of second creation very often will help promote the original works. When I receive a piece of secondary creation, I might have never come across the original, copyright work, and I might be encouraged to look up the original work. If secondary creation is done not for profit, then it should be fully exempted, and it should not be come under the exemptions for satire, caricature, etc., etc. And secondly, the right to share information, that is to receive and to disseminate information. If I receive a suspected secondary creation, if I find it very funny or very inspiring, then I might want to, share it with other people. However, if this bill became law, then the suspected secondary creation is already in breach of the law, and if I inadvertently forward it to my friends, and my friends receive it, they will forward it further to their friends, and all of us would have broken the law, and in the end, all of us would be in trouble. Finally, I'd like to talk about the question regarding safe harbor for network companies. If there are any complaints, they have to take down the works of secondary creation. I think the OSP should first of all obtain permission from the court, and only when they receive permission from the court will they do that. If the OSP has been set up to do business, and they should actually bear the responsibility. And finally, if the bill becomes law, how can we ensure that the netizens, especially those who are engaged in secondary creation, and we want to share what we have created, how can we be sure that we will not be arrested? Mr. Hong Shu Feng, Chairman, I am here in my capacity as someone who is doing secondary creation. I think last time we talked about marginal economic, prejudices, but this time the government is proposing exemptions for parody, satire, caricature, and pastiche. Many people already have commented on this point. And speaking on behalf of the vested interest, many people think that after the bill became law, that we can tackle illegal piracy or the illegal downloading so that the entertainment industry will go back to its past glory. But I'd like to point out that the times have changed. We're in an age of subculture. We're not living in an age of main culture. Main culture means that a society upholds a single mainstream value, and then you create according to that mainstream value. Whereas in the age of subculture, there could be hundreds of different values. People can freely express their different opinion. Take the Facebook, for example. You see media nowadays. People like to like and share what they have created. For example, we nowadays can proactively receive different types of information, and Facebook would not reveal that you have 100 of your friends issued 100 posts. They would let you. They will only show you the post that you're interested in. We are in an age of active information selection, and this is how we communicate. In the past, when we talk about comics, we talk about Dragon Ball and Gota, but nowadays, you have dozens of comics every quarter, and we wouldn't have the time to see them all. And because of the sharing information on internet, we can find a common interest, and then we can form a subcultural group, and then we can all share the same value and exchange information. Many artists now like to use Twitter. They just don't use it to promote themselves, but rather they use it as a tool for active, search of information. So we talk about interaction with the original work, and so the 4 exemptions will not be able to cover the entire ecology. Next, Mr. Lam Hing. Thank you. We are very, uncomfortable, we feel very uncomfortable with the bill. Originally, the government was silent, but now I think the government has now made a proposal which is an improvement. But for the other creative work, there are no such clear-cut protection. We've already told so other than that, we can also include drama and so on. However, the government, other than offering these 2 exemptions, the government would like to leave it to the commercial operators to solve the problem. So very often we would support the original works. We would like to salute the original creator of the works, and we would make a second creation. And what we create also include drama. And we don't know whether or not, according to the bill, it would be illegal. That is, if we seriously interpret the copyright works of other people, it is not subject to exemption, and we are shocked because to put a performance, we have to go through many rehearsals, lasting several months. We don't want our efforts to be wasted. Sometimes, even if we sing a song, seriously, we might be prosecuted. We don't want to see that happening. I know that there is also an infringement measure which is providing premises for the act of illegal infringement of copyright. We have the Convention Exhibition Center. At the activity stage at the Hong Kong Industry, the High-Tech Center, and some young people would lease industrial buildings to put up performances. Does the government want to also stifle such a space for performance? And this is not acceptable. The officials present today, we have Mr. David Wong, Deputy Secretary for Commerce and Economic Development, and also Ms. Fabian Tam, Assistant Secretary, as well as Ms. Michelle Zhong, Assistant Director, Mr. Deputy Secretary. All the deputations have now spoken. Would you like to make a response? Thank you, Chairman. We've listened carefully to the views of all deputations. We will also carefully study all the written submissions which have been put in. But I would like to, first of all, state what is our basic principle. The spirit of copyright law is to protect the author of the copyright works. We want to encourage creation. That is, the author of the original works is protected by law to own the economic benefits arising from such original, works which has created. So normally, without his consent, people cannot, make use of his property rights. But our law also accepts that such intellectual property right is not an absolute right, because copyright has a fixed term, and also there are many exemptions. That is, without the consent of the original author, you will not be allowed to use them. The existing bill doesn't provide for exemptions like education, commenting on current affairs, and so on. In which case you don't need the consent of the author before you can use such materials. A major purpose of the present bill is to update our copyright law, because if you look at the development of copyright laws in other jurisdictions, and that is to tie in with the emergence of the internet, we are providing for the communication right. So the main personal task is to provide for this communication right so that we can give greater protection to the author of the original works. But sometimes such rights may conflict with those of other rights. For example, other people making reasonable use of the work.
So there are different rights and different conflicts. In the law, we are trying to provide solutions. We hope that we can put together laws and rules, and exemptions will also be offered. So for this bill, other than providing other than the original proposals, now we are putting forward some other proposals. For example, the fair dealing exceptions for the purposes of parody, satire, caricature, and pastiche. Now, when we comment on current affairs, most of the time we will use parody or satire, so this will also be covered. So newly we have added commenting on current events. Now we have already exempted reporting on current events, and we will be adding commenting on current events. And the third area is quotation. For example, the capture of certain pictures, videos, etc. So these would also be exempted from the future ordinance. As for the safe harbor regime, we think it is appropriate because we can balance the right between the copyright owners, the platform, and the subscribers. The platform is not, or the OSPs are not required to actively police their service platforms. They just follow the code of practice of safe harbor. And as a copyright owner, if you see your work uploaded onto the platform and you think your rights has been infringed, you can talk to the OSP. You can notify the OSP that there might be an infringement, and the OSP would use a notice and take down mechanism. The OSP would have to notify the uploader, and if the uploader does not agree to this, he can send a counter notice to the complainant. And the complainant and the subscribers, if eventually they cannot reach a consensus, then they can resort to court proceedings. This is the principle of this bill, and we are following the better practices in overseas countries. We hope that we can continue to have dialogue with legislators and stakeholders so that the bill can be optimized. Deputy Secretary, can you respond specifically to certain deputations or representatives, because they think that the Copyright Amendment Bill 2014 is Internet Article 23, and they are afraid that even if they sing a birthday song, they will be penalized. And for secondary creation, if it's not for business purpose, can it be exempted? Yes, Chairman, I will try my best to explain. Under the present law, yes, indeed, there are certain criminal provisions handling the different infringements. For example, if you buy or sell the product, or if you communicate infringing copies for commercial interests, then you have to shoulder the criminal liability. It already exists in the present law. And if you are not making profit, but your act would infringe the interest of the original copyright owner, then there will be a penalty. For example, earlier on, we have seen an example of a netizen doing streaming. He put films onto the net, although he's not making profit, yet he has undermined the economic benefits of the original copyright owner. So this is criminal, and this is also in line with overseas practices. That is, under such circumstances, even though you're not making profits, other people's benefits are prejudiced. We are not going to change this arrangement, because this is a matter of principle. However, in the future, we are adding something new, that is communication rights. Now, on the internet, if you are not communicating an infringing copy, but you are doing streaming, we think that the same principle should apply, and this would attract criminal liability. So we are amending the law and putting forward a new criminal offense. So if you are not making profits, but you are causing more than trivial economic prejudice to the copyright owner, you may be held criminally liable. This is only to optimize the law. Ms. Chen Yunhan raised her hand first. Let her ask questions first. Mr. Well, yes, Chairman, yes, I am not a professional in this area, but I'm very concerned. Hong Kong is an international city, and in a lot of areas, we are very diversified, and we are pretty advanced. When it comes to parody, the government now provides exception, but a lot of people are still worried, for example, about secondary creation. Now, they may just be doing this in private. It's not done for any commercial profits. So how can they be protected? Deputy Secretary. Thank you, Ms. Chen. In the past year, we had done a lot of consultation. We actually were focusing on this issue. Now, if you use a copyright work, if you just do it in private, then it has nothing to do with communicating to the public, and this would not attract any civil or criminal liability. But what's the definition? It's very difficult to define. If you do something, you're saying that you have not disseminated. How about I show it to my friends? What's the definition? Under Secretary or Deputy Secretary, now in the Internet age, if for some copyright work we put it on the YouTube, then it would be disseminated, it's distributed, everybody can see it. This is copyright infringement. So from the legal point of view, the person that does this should shoulder the legal responsibility. But what if there's no commercial activity? If it's not a commercial activity, but if the consequence is that the original copyright owner's benefits is prejudiced, and there would be a problem. For example, if you have a film and then the film is uploaded by streaming and everybody can watch the film, then the original copyright owner would suffer. But if you do not put it on the internet, if you just copy it onto a VCD and give it to people, you are already infringing the copyright owner's rights. So if you use the internet as a platform, if you put it online and everybody can see it, in principle, this person should bear the responsibility. Now, if you put it into a DVD, then you have the intention to pirate the copy, to make a pirate copy. Now, for online copyright piracy, one of the way of doing it is to allow people to watch pirated movies online, and the audience will not be charged. But if a person does that, the copyright owner will be prejudiced, because then people won't go to theaters, won't go to cinemas to watch the movie. Mr. Charles Mock, when a government introduces certain exceptions, that is, there are certain acts, if you do these acts, then you will not be prosecuted. If you are doing this, but you are still criticized so seriously by people are saying that this is Internet Article 23, then I think the government should really review what it has done wrong. Now, in 2012, you must remember you were also then the chairman of the Bills Committee. That at that time, the bill was not passed because there was no exception for secondary creations. Now 7 exceptions have been added. It's like 7 helmets, but it seems that a lot of people are still very worried. So I would like to ask the government, Mr. Wong. Now, before the law is amended, would these acts attract civil or criminal prosecution? It's just that it has not been done before. Well, Mr. Lai wants to maintain the status quo. Does it mean that if the ordinance is amended, it would be easier to prosecute people who do this? Now, it seems that there's a knife above your, at the moment, there's a knife above your head, but you don't have a helmet. In the future, we do not know whether there's still a knife above your head, but you have 7 helmets. However, the public does not believe you now. Can you explain more clearly? Now, according to the present legislative proposal, if the ordinance is amended, do people run higher or lower risks? I would also ask Mr. Lai and Mr. Lok again. I think they really have a lot of things to say about this. They don't just want to listen to the one-sided story of the government. Deputy Secretary, thank you, Mr. Mock. Yes, let's talk about some basic things. Just now, I said that for copyright protection, the most important thing is to protect creative works, because these works were created by people, and at the same time, under certain circumstances, we accept that even without the consent of the creators, their works can be used. So how do we implement such a principle? That is, first, copyright is a property right, but it is not an absolute right. Even though a person has this property right, sometimes you can still use his works. Now we already have over 60 provisions which offer this kind of exemptions. For this bill, we are adding 6 scenarios under exemptions, and we are targeting the present internet situations. Now many copyright works are being used by people for other purposes. So now we are adding this as the fair dealing exceptions. We are actually expanding the scope of freedom of speech. You can still use some copyright works without obtaining consent from the copyright owners. And Mr. Mock asked if now there are already certain things that cannot be done. Well, under the present law, we are targeting the communication of infringing copies. And if the original copyright owners' benefits are privileged, then action will be taken. So it is not only confined to a concrete object, for example, photocopying books or copying a DVD. Even for electronic copies, now they are already subject to the regulations of the present law. That is, if you are communicating altered pictures or changing or altering songs online, then there would already be an electronic copy online, and you are already infringing their rights. But how come there has never been a court case like this? Because under the present mechanism, the copyright owner would have to prove that the copy is quite substantial, and the copyright owner actually suffers financial losses. If the copyright owner cannot prove that, then he really cannot target these works. If there is large-scale piracy, the copyright owner would rather file a complaint at the Customs and Excise Department, because that would help him lose less money. So now under the law, we already have a framework about infringing works, and it's not abused by people. With the passage of this amendment bill, we are increasing exemptions so that for ordinary users, even if they haven't obtained the consent of copyright owners, they can still do certain things. This is the spirit of the law. We want to balance the rights between users and copyright owners, because now we see a conflict of interest between the two, and both sides have their reasons. Now, people may say that, well, copyright is to protect my rights because I created, but other people who may think that parody and satire may help them comment on current events. So we think these are legitimate reasons, so that's why we are trying our best to strike a balance. Mr. Lok, do you want to supplement? I would like to talk about 118. We are very worried about 118. We think it's over-regulating, and it covers all technologies and all modes of communication. Well, it's not that by adding certain exemptions, this problem can be resolved. After amending 118, many more acts are excluded from exemptions. No matter how many federal exemptions you provide us with, that's still a problem. For a song, there are 4 copyrights. For example, MV, the singer, the melody, and the lyrics. So no matter what, you may infringe these copyrights. So you will always be caught. The government really wants to combat streaming, but while you do that, some other ways of communication would also be caught. For example, if you stream video game playing, you would also infringe other people's copyrights. And under the new amendment bill, this is a piracy act, so and there's no defense. Would you arrest the person then? I would like to follow up on 2 points. Just now, Ms. Chen cited an example. Now, if in her office she has altered some pictures, and then she wants to share these pictures with her friends. So according to Mr. Wong, is this considered communication, or is just something done in private? Now, just now, Mr. Wong cited some examples concerning making DVDs. So what if in Ms. Chen's office, there is an altered picture, and her friends comes into the office. Her friends really like the altered picture, and she takes away the altered pictures and shares it with her friends. So would it be considered as infringement?
Mr. Wong says that you are expanding the protection. However, even if you give us more helmets, you will not be able to exhaust every scenario. What is more important is that you should not be naming the exemptions to say that we will not be caught. I think the point is you should just provide a framework for exemption so that when a person engaging in secondary creation will just have to consider whether he will be operating within that framework. But of course, this already constitutes some limitation on freedom of creation. Now, can I ask a question? Under the law, if an originator can seek compensation through the court and by using civil action, then why do you still want to have this bill? I hope Mr. Wong will respond to this point. Ms. Zhang? I think I don't understand something. You always repeat that you will not limit satire. But at the same time, even if you provide this framework, many people will still be caught. Maybe we don't use it for advertising, but within our website, there may be advertisers. So does it mean that we'll still be breaking the law? DS? Thank you, Chairman. And the questions. It is said that no matter how much exemption we provide, there will still be some limitation on the freedom of speech or freedom of creation. But we are talking about two concepts here. One, the freedom of expression and creation. That we should protect and respect such freedoms. This is a principle under the law. But then, as I said, under our economic structure, the fruit or product of original creation should be protected by the law as an intellectual property. Now, so who should override the other? If I look at it from the originator, he would say that I should be protected by the copyright law because I am originating that creation. But as for the user will say my freedom of creation is also important. So we are talking about a conflict of interests. Our legal system has to deal with such conflicts of interests. In our economy, under the present copyright law, in fact, the world is also regarding copyright as an intellectual property. And if I prejudice that intellectual property right, I must do it for a valid reason. And that valid reason must be translated into legal language, which will speak of exemptions. In other words, even if you have the intellectual property right, I can use your property. That is what we are doing. And this is also the starting point for providing exemptions under the copyright treaties. And this is exactly what we are trying to do in the bill. We are providing for more exemptions so that we can balance the interest of the original creator and the user. Maybe Ms. Chong can talk about posters. Yes, Ms. Chen Yunhan asked a question. And also a deputation mentioned that if there is a picture at the ward office of a member and if it is sent to the older people in the district, whether it will constitute publication. Now, under the copyright law, we are talking about publishing to the public or communicating to the public. What matters is the word public. If you do it through email in your office, that will not constitute publication. That would not fall within the definition of the public. In other countries, publication or communication in the UK, Canada, and Australia, that is regulated. But nobody has defined what the public is. But under case law, we have agreed that we talk about a social circle and we talk about acquaintances. These people are not the public. So under the law, if you communicate to the public, then we are not only talking about your social circles or your acquaintances. I hope this can help to deal with the worries of Mr. Chen Yunhan. And Mr. Charles Mock is saying that we seem to be introducing 7 helmets, and does that mean more protection? Well, yes, we can analyze it this way. At present, publication, as Mr. Wong said, according to the Big Crook case, it is not only limited to physical copyrighted works, but it also includes electronic copies on the internet. Now, if that's the case, what are we adding to publication? This is because under the present ordinance, under publication, there is this important word, and that is copies. In other words, you make a copy of the work. But if you look at the present communication mode, you might not need to make a copy before you communicate it. And somebody mentioned streaming. We watch a lot of things on the internet, and you don't need a copy to watch it, because when we watch it, we do it by streaming, and after watching it, we do not have a copy on our own computer. This is the gap in the existing ordinance. But we need to protect it under the right of publication because we know technology is developing fast, and so our law cannot only dictate the mode of communication. If we believe it is a technology neutral is important, then we would also want to relax the regulation under the copyright ordinance. We are talking about distant learning and the passing of messages through intranets. And on a daily basis, if members of the public want to communicate copyrighted works, and they can do it for certain reasons, they want to discuss matters with people, they want to comment on a current event, they want to satirize something or parody something. This is exactly what we have added as exemptions. So in their daily lives, the public can reasonably make use of copyrighted works. Mr. Mock said, is it that these exemptions are in a way helmets, in other words, protection? Well, yes. As I said, if publication is not limited to a physical product, and if we don't have the exemptions now, that would mean that as a point of law, if we capture an image and we communicate it on the intranet, and also if it is not just for your friends, then perhaps you would have infringed the copyright. In other words, the copyright owner can sue you through a civil suit. Of course, the right remains with the copyright owner. Now, we'd like to reassure the public with the 7 exemptions, because with these exemptions, the copyright owner may not be able to seek civil compensation, because they know that actually the works have been used for commenting on current events, that it was used for satirizing current events or for discussion. So it's some kind of progress. A friend has come in. I will allow the person to speak. Maybe you should wait. Or we will allow you to speak now. Mr. Kwok Chi Chung, you have 2.5 minutes. It's not a a lot of time. I am speaking in my individual capacity. I can see in Annex D, I think there is a problem with the description there. In Annex D, footnote 5, it is said that you will parody something for making people unhappy, or you do it for not a proper purpose. In March 2012, there was a parody of a traditional Chinese poet who is said to be very busy. Now, this ancient poet was made to be doing a selfie, holding a pistol, playing on the guitar, riding on a motorbike, playing basketball, and also playing with a cat. And there is another parody series which happened in February this year. The Japanese TV station interviewed a couple in the snow, and the netizens liked it, and they turned it into a lot of comic pictures. For example, they turned it into well-known characters in other comic series. They are turned into such characters. These have appeared in different Japanese comic series. They have even turned the girl in the couple into a girlfriend of Uncle MacDonald. Now, such, in fact, does not fall within the 3 areas of exemption. A capture image from a TV show has been used. Does it mean that he has broken the law? And in Annex D, you have used negative wording that people are made unhappy because of it, and low quality reproduction. Are you trying to lead the public to think that parody is something evil? From the 2 examples I quoted, you can see that the parody has been done so people will find it funny and people would get a good laugh out of it. Do you really want to criminalize such people? Chairman. Yes, DS. Let me directly respond to this question. We use that kind of description because we were taking it out from other literature. We were not trying to be negative. And we were trying to explain what parody and its exemption would usually cover. Just now you quoted the examples, and I can say that that is exactly what we want to exempt under parody. Okay, another friend has come in. Mr. Ko Chin-yong, you have 2.5 minutes. Looking at the amendment bill, I have some unease in my heart. What was subsumed under publication has been included in this bill. I find this quite terrible. If you do this, supposing I like to play a sonata by Beethoven or somebody, if you include everything, then some people may do something rather strange, that I have played that piece, and other people will play the same piece, and if I can then sue other people, that will be a problem. The court may say that the case will not be upheld, but it will still instill horror in people's heart. And you will always feel the risk of being sued. I therefore object to the amendment bill. Thank you. Mr. Ma Fung Kwok. Thank you, Chairman. There was a deputation addressing the question I asked this morning, and that is secondary creation. I have been asking you, and this is a question for the deputations. I, of course, understand what you want to do with secondary creation, but we are talking about legislation, and legislation must be specific, and there must be clear definitions. I'd like you to try to come up with a definition of secondary creation. I am at the 4th session, and nobody was able to answer that question in the last 3 sessions. Secondly, after consultation, the administration has come up with this new bill, and it has included your concerns. And also, what other countries are providing under the law to protect the freedom of creation? Well, it may not be comprehensive, but there are exemptions provided. And initially speaking, I would say that we have already covered what other countries do, including the US, UK, and Europe. A safe harbor has been provided, and there are exemptions. I believe the bill is quite good. What is lacking from your point of view? If you ask me, I would really like to help people who do creative activities to have as much exemption as possible. But of course, you have mentioned UGC, user-generated content. The administration has not included UGC. Now, apart from that, what is lacking in the bill? Well, the catchphrase now is international standards. We have already taken reference from other advanced places when we wrote this bill. What else do you not like about this bill? And the administration has said clearly that the administration will only enforce the law upon a complaint from the original creator. Now, if there is no economic loss caused, I can't see how the originator of a work will bring litigation. I believe the bill seeks to strike a balance. So what do you think? In your view, what is lacking in the bill? Yes, please. Yes. I'd like to respond to Mr. Ma's question. Well, I was talking about you who said that secondary creation is hard to define. And therefore, I find it strange that the administration was able to list a list of exemptions. I can see from the administration's paper that some types of works have been listed, but you can only say this is a list of what you see in the internet until October 2014. But does it mean that that is all there is? Well, no. There will be new people coming up, and they will be doing secondary creation, and a few years later, people would again do some other kind of secondary creation. Now you list the types that will be exempted, but what about new kinds of creative activities that will come up? Is it that you have to amend the law? Because the internet is changing fast. Do you want to change the law once every few years? And since it is so difficult to define, the copyright owner can choose to sue or not to sue. He may be of the view that this is not included within the exemption, so you still face a lawsuit. The copyright owner may be very rich, and for those who are earning less than $14,000 a month, it will be very difficult for them to face such legal challenges. And the administration has been quoting the Big Crook case. But secondary creation cannot be directly compared to Big Crook. You also emphasize that intellectual property has to do with copyright using. But secondary creation has nothing to do with intellectual property. It may be just a case of happy share. Well, yes, you should be concerned about intellectual property right, but then you are affecting the public and their freedom of expression. Therefore, when you amend the law, yes, it's all right for you to be concerned about the rights of the copyright owner and intellectual property, but at the same time, you must allow people channels for secondary creation.
Mr. Lok. I have a question regarding UGC. The point is not whether or not we have a definition for UGC. We're talking about how we can, apply other jurisdictions' way of invoking the copyright laws without jeopardizing the interests of the owners of copyrights. So for both sides, I think there should be clear provisions. Only then will we have the space for creativity and also for commercial development, and also the exchange of information and the communication of knowledge through the internet. Why? Well, the netizens are most dissatisfied with the fact that you need to cater for the future development of technology. You need to be technologically neutral. Why is it that in your exemption provisions you are not bearing in mind the future needs? I also like to talk about the Berne Convention. What the convention recommends is that is as to when we should resort to criminal prosecution. And they only recommend that only when you have large-scale infringement activities would you need to prosecute. The big crook, for example, I think it's like planting a seed there and 3 people downloaded the film, and I don't think you'll be able to invoke this criminal provision. But the government is too impatient to really, wanting to get a first case law. And I'm worried that in future there will be even more serious cases of abuse, and the government would invoke this section of the bill. Mr. Lai? Mr. Lai Chipo, I've asked you to speak, so perhaps you can start. Mr. Kwok gave a very good example. I like the poet tofu, what is meant by parody, and he challenges certain wordings in the bill. The Deputy Secretary said that that is not the intention to ridicule a particular adjective, and I think this is exactly a major problem with your bill. You are using very limited text or terminologies to encompass and to try to exempt unlimited, an unlimited amount of activities. So I think it's for the person to come up with the terminologies, and it can't be helped that there will be omissions. So perhaps I can change my analogy, and we shouldn't be talking about helmet anymore. The exemption that you propose now are knives. If I am a suspected person engaged in second creation, I would need to consider whether I would like to plant this knife. Mr. Wong could perhaps explain this. That is, how, well, just because you've come up with all these exemptions, so the people are suspected of engaging in second creation. In the course of doing that, how can they, bypass all the traps? And also, in the course of doing so, the cost would go up. So how can you allay this concern? Many other persons already pointed out this is an important part of the bill, and we don't want the administration to so casually, endorse and enact a bill which may, seriously stifle the freedom of creation in the future. I think this gentleman has put it most correctly. I believe that the public should have the right to engage in a debate, and we shouldn't just always be just talking about where we should have a meal and so on. When we are engaged in a dialogue or debate, we should do so. It should be based on principles. We shouldn't just utter nonsense. We need to, find out the relevant evidence, or we may need to quote what other people have said or written. Otherwise, the current affair programs will all need to be scrapped. Why is it that you allow for current affair programs to broadcast, and at the same time you do not allow for the internet radios? The public should at least have the freedom to quote what someone else's have said and post it on the YouTube. Only then would it be fair. Otherwise, if you criticize a certain person, you could be sued. If I don't make any comment, I just quote what somebody else has said, and I don't even have the freedom to do that, then it would not be acceptable. Many people have said things which are totally unreasonable and really have exerted a bad influence on the rest of society. So I think that should be the minimum requirement. You have radio stations, broadcasting current affair programs. So can the public. They can also comment on current affairs, and among members of the public, they could, communicate certain things, and that should be allowed. Madam Cheung, you think? Thank you. In the final analysis, the Deputy Secretary has never answered the question regarding the framework. He's been beating around the bush, and the government all along has been trying hard to tackle the Article 23. For the purpose of second creation is to allow the public to give the public the right to know, and know. When we're going to have the internet version of Article 23, you will be defending the producers of movies, TV programs, and corporations. As a result, those who are involved in creative works will be stifled, and there will even be more far-reaching implications that people dare not even dare to engage in second creation. I hope you can really think about this carefully and do not impose excessive restrictions so that the scope for creativity will be stifled. Mr. Kwong? Mr. Ma Fong Kwok said that certain things could not be exempted. What we're worried about is the remixing of a piece of music or the rearranging a song. That is not included in the bill. You may listen to the Golden Music Station, and they may play certain songs. You may not know that some people may draw certain comics which is based on the original plot or story, and it has been suggested that this is called derivative works, and that is not included. For example, in certain second creative works of comics, they very often will use the word nectar, and you need to have read the original story first before you understand where the humor is. Like the film Shaolin Football, some of what is created may not be parody. You must have first seen the movie Shaolin Football before you can appreciate the humor of the derivative works. To say that such derivative works will, take away the profits of the owner of the original work, then I'm worried that such works will not be protected under the proposed bill. I've been reminded of one thing. In Japan, there is a very well-known apps. It's a voice, synthesized voice software. If we adopt this criterion to draft the amendment, I think we've all heard a particular song, Gam Ho Lai, and people will recreate, other songs based on the lyrics of that original version. In future, such secondary creation will simply be stifled. If I have to take one word out of the original music and reinterpret it and turn it into a song, that will not be allowed. So the scope for secondary creation simply will be narrowed. Mr. Chairman, I also have one more concern. When I spoke earlier on, I gave the example of a remixed version of the song Happy Birthday. On the internet, I've seen a series of songs which being created in the same way. They use the same song, they change the tune by computer mixing. For example, the major will become the minor and so on. And the song itself. The purpose of the author of that piece of music is to show people what the song sounds like after you've changed the keys. It may have nothing to do with caricature or parody. But the present amendment may not be able to cover such scenarios. If I use the original recording and use that as the basis for secondary creation, and if that type of creation cannot be covered, then it may not be too satisfactory. Mr. Koo, I hope you are, focusing on the question raised by Mr. Ma. Mr. Ma Fong Kwok made one point, that is, the provisions in the law should be clear. But if we look at the provisions of the bill, one problem is that parody, caricature, and so on is something that is very subjective. A well-known person like Wang Hawai, she had her own unique set of views. Some people find her to be very funny. Other people hold different views, and it's all based on subjective reaction. So if you seriously try to, display a very funny, theme or vice versa, then will the author of such works have worried that they will be caught, and therefore they will lose the incentive to do such creative works. Deputy Secretary. Thank you, Chairman. I'd like to thank all the individuals for reminding us of your concerns. We'll certainly consider them carefully. Starting from the principle, we live in a society which is composed of many different individuals. I think we should all have our respective rights, and whatever we do shouldn't hurt the interests of other people. That should be the starting point. If we accept that copyright is a property right, copyright is a copyright and should be protected, then my behavior should not damage the property right of another person. But of course, there are certain reasonable scenarios for which we should come up with exemptions and allow for things to be done if they are reasonable. That is, if I quote something to help me make comments about current affairs, or if I want to create a satire about certain current issues, then the bill will provide for such exemptions so that people can do it. And the law will also provide a clear definition to deal with, possible conflicts among people. The law would need to be drafted with, with words. The concepts that we use, or whether we're talking about parody, caricature, commentary on current affairs, we've actually made reference of the laws in other jurisdictions and the terminologies that they have used to meet our needs. Of course, we understand that the method of creation may vary, and in future, if there are new forms of second creation, what should we do? Does it mean that the freedom of creation will be restricted? If we make that argument, then we have to deal with another question. That is, how can we draft a bill? Does it mean the freedom of creation should override the interests of the owner of the original works? Secondary creation is a way of using other people's works to come up with a new product. But does that give you sufficient justification to come up with a new exemption? I think there are some difficulties if one makes reference of the International Convention. Some of you ask whether or not we need to change the copyright laws once every few years. If there is a new situation arising, then we may indeed need to amend the law accordingly. We only had the copyright law in 1997. It's now 2014. And once every few years, we would make amendments in order to catch up with the latest development in technology. We would amend the law once every few years. The last time it was in 2007, and during the interim, the law has been amended several times. We would need to, take heed of the current latest development. Take UGC, for example. Canada provides for that now, but there are other jurisdictions which decided not to exempt that after they've studied the issue. But I would not rule out the fact that the internet technology will continue to develop, and the government may need to deal with any new scenarios which may arise. We certainly don't have any intention to rule out that possibility, and we'll review our copyright law accordingly. But the present amendment proposal, stems from the fact that since we have the Internet Convention, many countries already upgraded and amended their copyright law to cope with the change of times. And Hong Kong is actually lagging behind Australia, Canada, the States, Singapore, the UK, and the EU. So if our legal system is not so, perfect, then we believe that there is a need to modernize our laws. The questions raised by the deputation. So we fully understand your concerns, and after we've struck the balance, we will try our best to come up with exemptions which are justifiable. We believe that this is the right time for us to do it. We certainly look further and study the views that you have proposed. On the subject of copyright, there are many outstanding issues that we need to tackle. And every time we deal with them, all the stakeholders will put forward their aspirations to us, be it the users, the OSP, ISPs, and so on. We will need to consider all these aspirations to ensure that the proposal we put forward to LegCo is a balanced proposal that would be conducive to the maximum interest of Hong Kong. Mr. Charles Mock, Chairman. Having heard the discussion for the entire day, and having heard those representing the industry and the general public, I would also like to make a brief summary. The analogy I made just now, I think I need to further explain. Before we amend the current legislation, Mr. Wong already answered the question just now. Above your head there is a knife. It could be a big chopper. Fortunately, it has not dropped onto us yet. We don't know the reason why, and you don't have a helmet on your head. The exemptions which are now proposed, indeed, these have been implemented in the last 10 years or so in the West. That is providing helmets. These are not very, very sturdy helmets. It could be made of wood. And the government has now come up with 7 such exemptions. Some of you made it put it very well that these scenarios cannot be totally anticipated. The government now has come up with 7 scenarios, and they are prepared to give exemptions. So given the uncertainty, should we now accept these 7 exemptions now, or should we refuse to accept the 7 exemptions because it doesn't provide for 100% protection? Or a more progressive approach, I think, is like someone suggested, that the 7 exemptions may not be enough because it's not exhaustive enough. It cannot cover things that we consider important. And they proposed UGC, for example. We can have a discussion as to whether we can accept that. Some people say the problem, if you were to rearrange a particular song, then can you give me an 8th or 9th exemption, and so on.
The Tongxinxi people also think that they want more exemptions. So if you want this 8th, 9th, or 10th helmet, I think you really need to discuss it more. Now there are 7 helmets, and if you don't want them at all, I think it's unreasonable. This is my view. And just now, the government official answered the question. In particular, Ms. Chen Yinhan asked the questions concerning whether the work will be communicated to the people. So can you also tell us more about substitution? If we cannot substitute the original work, then there should be no problem. Can you explain more? On this point, I think it is also one very important point. Now, today we have heard many examples. Well, other than the Tongxinxi example, and also the song lyric changes, these are exceptional examples. But for the other examples, I think they cannot substitute the original work, right? Or the underlying copyright work. Oh, thank you for your question. Maybe I can spend some time talking about substitution. In the law, there are civil rights and criminal rights. Now, the copyright owner can always sue you. So why do we need to make the amendments? Well, we are doing this because we want to provide some civil rights to the copyright owner. And this is the spirit of the communication right. And also, it is about criminal liability. If you communicate something and it prejudices the original copyright owner, then there would be a problem. So you would ask what is meant by prejudice. Well, I don't know whether it would prejudice people. Well, this is a reasonable concern. So after discussing with the last Bills Committee, this time around we conduct another round of consultation and we talk to netizens as well as copyright owners. Now we have a clearer concept. Well, the one who's accused of infringing copyright, whether the new work would substitute the underlying copyright work, this is a very clear indicator. Now, if it is alleged that a certain work is an infringing work, then the court would have to consider whether it would substitute the underlying copyright work. If it does not, then it would not prejudice economically the original copyright owner. And also, civilly, we have provided for some exemptions. If you are not caught by this, and you cited some examples, those examples would not substitute the underlying copyright work, so it would not compete with the original work in the same market. So if a person just wants his rights back, then he can do 2 things. First of all, he must have clear evidence showing that he is really prejudiced, his right is infringed. And secondly, he can produce evidence at court proving that he's really suffered losses. He should be able to quantify the losses. And if he cannot prove these, then it's very difficult for him to win a civil case at the court and get damages. And for our civil proceedings, we would not handle frivolous and vexatious claims. So the legal system has already provided sufficient protections. Members, do you have any other questions? If not, then let's wrap up this session. Well, the government has heard a lot of views today. The deputations and individuals have made a lot of comments. So I hope that you can summarize all these comments, give us a table in writing so that we can follow them up in the coming meeting. So once again, I would like to thank the deputations and individuals for coming to our hearing. I'm sure your comments will be very helpful to our members. Thank you. Meeting adjourned.